Despite the Supreme Court granting, vacating, and remanding review of a magazine ban case, a lower court has continued its defiance and has upheld a magazine ban, but at the same time struck down a narrow aspect of the state's rifle ban. This decision is now set up for review, but currently what is happening is California's magazine ban decision is now coming into play as support for the state ban. Now, before we jump into the video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements. I use their protein powder and a lot of their supplements every single day, trying to get healthier. But one of the cool things about them, they're pro-freedom, pro-America, and they support what we do here on the channel. So if you're interested, check out 1st Phorm using the link down below. And if you order something $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, I'm going to be discussing 2 critical cases which challenge a state's ban on rifles and magazines. This magazine ban case was recently granted, vacated, and remanded back down to the district court for a new decision in light of what the Supreme Court said in their 6-3 Bruen decision. Well, that district court on re-review issued a new decision in 2 consolidated cases, and those cases are ANJRPC versus Platkin, and then also Cheeseman versus Platkin. And in this ruling, the court came to the most perplexing and outrageous Second Amendment analysis that I've seen in a long time. The court found that the state's ban on the Colt AR-15 is unconstitutional and it must be struck down. However, it then decided to not rule on any other aspects of the state's rifle ban, so it didn't address any of the other rifles in question. And then it also found that magazines that hold more than 10 rounds are in fact arms for the purposes of the Second Amendment, but then also found that the state can still outright ban those items. This horrible decision has now been appealed to the Third Circuit Court of Appeals for a reversal, but now the state of New Jersey is trying to use the Ninth Circuit en banc panel decision in the California magazine ban case Duncan. They're trying to use that as support for why the Third Circuit should uphold the magazine ban and also the rifle ban. This now shows how critical it is when you get a horrible decision in a circuit court like the Ninth Circuit and how that can impact other state challenges as well. Now, this case involves the state of New Jersey's ban on so-called assault weapons and their magazine ban that is currently in place. When it comes to the magazine ban back in 2018, the state of New Jersey passed Assembly Bill 2761, banning the possession of firearms magazines with a capacity to hold more than 10 rounds. The case was then returned to the district court where a motion for summary judgment was granted in the state of New Jersey's favor. So that was a final merits decision and it was ruled in favor of the state. That again was appealed to the Third Circuit. However, the new panel rejected those arguments and then a petition for en banc panel rehearing was sought. It was denied by an 8-6 vote that very following month. That then led for the Supreme Court to get involved. A Supreme Court cert was sought back in 2022 on the final merits of this case. Now, after the Supreme Court issued Bruen, the Supreme Court decided to grant, vacate, and remand this case back down to the district court for a new decision in light of Bruen. The district court then consolidated multiple cases and decided to rule both on the state's magazine ban and also the rifle ban. Now, in the new final merits decision, the district court showed how it was not going to faithfully apply what Bruen said because the judge believes that the Supreme Court got the analysis outright wrong. In the ruling, the district court judge stated that it is hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table when frequently radical individuals possess and use these same firearms for evil purposes. Despite that, the court stated it was bound to have to follow the ruling in some way, and as a result, it issued kind of a hodgepodge decision protecting only limited sets of rifles, but at the same time, upholding magazine ban, finding that magazines that hold more than 10 rounds can be restricted. When it came to rifles, he found that given the variety of firearms regulated by the assault firearms law and the nuisance that each individual firearms presents, the court's analysis on this law is limited to the firearm which the court has been provided the most information, the AR-15. The court decided to arbitrarily limit review of this case to just the AR-15 and ignore all the other semi-automatic rifles that are also restricted under the law. Then when it came to magazines, the judge did everything possible to twist Bruen with the goal of upholding the magazine ban. The judge found that magazines are arms within the meaning of the Second Amendment and that the precedent that is in place in the Third Circuit shows that magazines are in fact arms. Now, with a court finding that these are arms and they're protected arms, you would think that the magazine restriction should be struck down. Well, no. What the judge then did is twist the Bruen analysis to uphold the magazine ban. The judge then decided to deploy what is known as the more nuanced approach based on new societal concerns to find that magazines could be restricted within the state. So in the decision, the judge strikes down only the one aspect of the firearms law, the AR-15 restrictions, but then avoided ruling on all the other semi-automatic rifle restrictions that are in place, and then it upheld the magazine ban. But now that horrible decision is being appealed to the Third Circuit, and that's pretty much good because this is also a final merits decision. In the appeal, the plaintiffs argue that the court started off on the right foot, holding that New Jersey's ban on AR-15s, America's most common civilian rifle, is unconstitutional. But the court then arbitrarily cut plaintiffs' challenge to all of the rifles, pistols, and shotguns New Jersey outlaws as assault firearms down to just the most popular one. That was inexplicable. Meanwhile, as to magazines, the district court correctly held that the banned magazines are arms covered by the Second Amendment's plain text. It recognized, too, that they are in common use for lawful purposes, but things went south from there. In attempting to apply a nuanced version of analogical reasoning, the court suddenly, and without explanation, held that the state's ban on possessing these arms was merely a restriction on how people may use them. So this is now on appeal to the Third Circuit, arguing that the district court just plainly got the analysis wrong and twisted the Bruen analysis. But in response, New Jersey is now using the recent 9th Circuit en banc panel decision in the California magazine ban case as support for their bans in the state of New Jersey as well. In the notice to the Third Circuit, the state of New Jersey argues that the state advises this court of Duncan versus Bonta, which rejects the Second Amendment in takings challenges to an equivalent state restriction on magazines. The 9th Circuit is now the 5th post-Bruen circuit to reject the plaintiff's claims, with none holding to the contrary. As for the Second Amendment, Duncan upheld the LCM restrictions on two grounds. First, it identified a tradition, beginning before the founding and continuing throughout the nation's history, of legislators enacting laws to protect innocent persons from especially dangerous uses of weapons once those perils have become clear. It invoked, in particular, restrictions on trap guns, Bowie knives, slug shots, concealable pistols, and gunpowder storage, the history New Jersey details here. And it held that a more nuanced approach was appropriate in reviewing this history because this dispute implicates both unprecedented societal concerns and dramatic technological changes, but emphasize the same result would be proper regardless given the strength of the unbroken history. The court also rejected plaintiffs' simplistic approach that because many firearms owners own these magazines, that should be the end of this analysis. The court explained that this approach was incorrect and inconsistent with the animating Second Amendment principles and precedents. Duncan also rejected the Second Amendment claim because LCMs as accoutrements are not even arms, nor are they necessary to operate any firearm. And the takings challenge failed because Bruen had no effect on the court's prior takings cases, nor had other intervening decisions impacted that either. So the plaintiffs in this case have now taken this case to the Third Circuit, and they're trying to show how the court there, the lower court, was issuing a very incorrect decision, how the analysis deviates so far from Bruen. However, you now have the state here, New Jersey, trying to use another case decision out of the 9th Circuit upholding the California magazine ban. They're trying to use that as a justification for why their magazine restriction and then also the rifle restriction should be upheld as well, similar to what happened in the 9th Circuit. All of this shows why it's so critical for the Supreme Court to finally step in on this issue of rifle and magazine bans and to kind of correct what the lower courts are doing and how they're outright defying Bruen and not correctly applying that analysis. There's currently the Snope and Ocean State tactical case, which are in front of the Supreme Court, and that deals with rifle bans and magazine bans. Those have been relisted 10 plus times. We're seeking Supreme Court review to finally address the issue of rifle bans and magazine bans. But as of right now, it seems like the Supreme Court continues to pump those issues. We're hopeful that they will finally take up those issues in those cases and address that. And of course, this would impact all of these challenges. This one in New Jersey, all the ones in California, Illinois, all of these challenges dealing with rifle bans and magazine bans could be addressed by the Supreme Court if they finally take up this issue. So this is a very important appeal that we're going to be keeping our eyes on closely to see how this develops in the Third Circuit, but also maybe how Supreme Court action or other actions like those out of the 9th Circuit will impact the outcome of this case. So as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.